Thank you, Mr. President. 40 years ago, the United States Supreme Court ruled that non-union public workers who benefit from the work conducted by a union to negotiate contracts that they benefit from should have to pay a fee to cover costs associated with this work. If all workers benefit, it's only the right thing that everyone contributes a fair share fee. However, in recent years, there's been a well-funded effort by special interest groups backed by corporate billionaires to dismantle unions and silence the voice of workers. There have been a number of attempts to overturn the 1977 decision in Abood versus Detroit Board of Education. Other efforts have targeted state legislatures where they've had success in many states. In other states like Pennsylvania, these efforts were blocked. Workers have already the right to decide whether or not to join a union. They have that right to decide. It is common sense that if these workers benefit from the higher wages and better working conditions that result from contract negotiations undertaken by the union, that those workers should have to chip in for the cost of these negotiations. That's just fair. These negotiations get results and they benefit workers. They benefit workers who are in the union and benefit workers who are not in the union. The right to bargain collectively has been an integral part of raising incomes and growing the middle class over the course of the last century. Being able to organize and bargain collectively allows workers to demand higher wages and salaries and, of course, boost their incomes. These workers have more money to provide for their families, to increase consumption, which in turn increases both production and employment. Putting more money in the hands of workers is good for workers and for the country. Over the last several decades, we've seen the balance of power across our nation tilt more and more in favor of the wealthy and the largest corporate interests at the expense of working Americans. The Supreme Court has not been immune from this trend. Under Chief Justice Roberts, the court has become an ever more reliable ally for big corporations. A major study published in the Minnesota Law Review in 2013 found that the 4 conservative justices currently sitting on the court, Justices Alito, Roberts, Thomas, and Kennedy, are among the 6 most business-friendly Supreme Court justices since 1946. So 4 of the 6 most business-friendly serving on the court at the same time. A review by the Constitutional Accountability Center, which is an ongoing review and is updated with every case the Supreme Court decides, that Accountability Center shows the consequences of the court's corporate tilt, finding that the Chamber of Commerce has had a success rate of 70% in cases before the Roberts Court, a significant increase over previous courts. These are all critical cases. These are cases of critical importance to everyday Americans. Cases involving, for example, rules for consumer contracts, challenges to regulations ensuring fair pay and labor standards, attempts by consumers to hold companies accountable for product safety, and much more. Well-funded corporate special interests do not have the best interests of working families at heart. They're pushing these efforts to reduce their bottom line by reducing your incomes, the incomes of working families. That's why we're standing today to make sure that the voice of working Pennsylvanians and Americans are heard. To increase incomes and strengthen the middle class, we need to stop the assault on workers and labor unions, whether it happens in Congress or in state legislatures or indeed in the United States Supreme Court.